Good afternoon. Our last case is in the matter of A.G.J., and we will hear from the appellant.
Mr. Chief Justice, and may it please the court, my name is South Moore, and I represent the state of North Carolina. I am pleased to be joined in the courtroom today by John Godfrey, a third-year law student at Duke University who assisted the state with the briefs in this matter. I would like to reserve 5 minutes for rebuttal. Section 7B 2501 of the Juvenile Code requires a trial court to hold a dispositional hearing for a juvenile who has been adjudicated delinquent. The purpose of that informal hearing is for the trial court to select from among the juvenile's range of statutorily permissible dispositions a disposition that simultaneously protects the public and satisfies the juvenile's unique treatment and rehabilitative needs. Subsection C provides 5 factors for the trial court to consider during the hearing. This appeal presents a narrow but important question. When assessing whether the trial court considered those 5 disposition factors, may an appellate court look at the trial court's entire disposition order, including documents the trial court considered during the hearing, and incorporate it by reference into its findings? The Court of Appeals said no. According to that court, a trial court must not only make written findings specifically addressing each disposition factor, but also must make those written findings in a specific portion of the administrative office of the court's pre-printed disposition form titled Other Findings. Respectfully, the Court of Appeals is mistaken. The plain text of the juvenile disposition statutes merely requires the trial court's disposition order to show that the trial court considered the disposition factors during the hearing. By requiring written findings tracking each disposition factor in the Other Findings section, the Court of Appeals superimposed a requirement not found in the statutes. And while resort to the plain text of the juvenile disposition statutes is sufficient to decide this case, the structure and purpose of the juvenile disposition statutes further reveal the Court of Appeals' error. Accordingly, the state respectfully asks this court to reverse the Court of Appeals' decision. Now, before I get to the merits, I want to briefly address Annie's motion to dismiss this appeal as moot. The state concedes that Annie turning 18 moots this appeal, but the court should nevertheless deny Annie's motion because the state's appeal satisfies the public interest exception to mootness. Our Constitution and statutes give this court jurisdiction to resolve legal issues even in moot cases. For obvious reasons, this court is selective about when it chooses to use that jurisdiction, but one circumstance under which it may is when an appeal presents a question that involves a matter of public interest, is of general importance, and deserves prompt resolution. And as this court explained just last month in State v. Dahl, appeals from lower court decisions that are in tension with the statute's plain meaning are good candidates for the public interest exception. This is just such a case.
But I could distinguish Dahl because what's going on in Dahl that makes it important to the public interest is that it came up because of COVID, and that it's particularly, as we learned from the pandemic, hard for courts to engage in these kinds of complicated analyses in the middle of a pandemic. And so it was important to have that jurisprudence resolved in case we have another pandemic. Let's hope we never do, and courts aren't put in this situation again. And here we sort of don't have this. I mean, the idea that you would say this really sort of in the weeds question about findings in a juvenile delinquency proceeding is a matter of public interest, like, just sort of seems like a stretch. Do you get what I'm saying with that? So what is it about the legal issue that's so significant we can invoke this exception?
Well, Your Honor, in addition to the tension between the Court of Appeals interpretation and the plain meaning, I think there is the recognition by Judge Stroud in her dissent that there is some confusion among the judges of the Court of Appeals about what the proper standard to review disposition orders is. I would also note that some juveniles have told the Court of Appeals that this issue is one of public interest, warranting consideration even when their cases have become moot because they have turned 18.
But doesn't, if this is a recurring issue, doesn't that weigh in favor of not addressing it because it's going to come up again?
Your Honor, it will come up again, but because it will come up again in the Court of Appeals for certain, but because of the decision below, they are now going to be bound to ignore the documents incorporated by reference and other parts of the disposition order. I think it is very difficult, though obviously not impossible, for a juvenile disposition order case to make it all the way to this court. There are several reasons for that. One is just if a juvenile turns 18, in some, though not all cases, the case becomes moot. Another is juvenile dispositions at the level 1 disposition level can never last longer than a year. And so the disposition would expire before there could be 2 levels of review, of appellate review. And so because this case is already fully briefed, it has been argued, and it presents this issue, I would urge the court to exercise its discretion to consider moot cases in the public interest and resolve this case on the merits.
But isn't that a different exception to the mootness doctrine? It sounds like you're arguing to us now that it's capable of repetition but evading review.
I am not trying to specifically invoke that doctrine, Justice Earls, in part because that also depends on it being capable of repetition to the juvenile, and obviously that is not the case here. I am more making just a pragmatic argument about how likely it is that this court would be in a similar position to address this issue if it recurred because of the practical realities of juvenile disposition orders.
Just a final question for me on this point, and that is, if you're urging us that this is an important case that we should exercise our jurisdiction even though it's moot, and the reason that is because there's some confusion in the Court of Appeals, and from your perspective, the Court of Appeals has resolved this in a way that's contrary to the statute, it doesn't, where do we draw the line? Because almost every, like we hear a lot of cases where the allegation is the Court of Appeals has ruled in a way that's either contrary to a statute or contrary to our other opinions. And so how do we draw the line on mootness, or do we just hear everything?
No, Your Honor, I don't think you should hear everything. And I think that's why those pragmatic concerns about how realistic it is a juvenile disposition order would survive two levels of appellate review before becoming moot are so important. Again, the time window for when these orders are not moot and could be considered by an appellate court is often so short, and that's why I think this case is a particularly good candidate for this court to consider, notwithstanding mootness. Turning to the merits, the Court of Appeals erroneously held that a trial court must specifically address each disposition factor in the disposition order's other findings section. The Court of Appeals reached that conclusion by misreading 2 statutes, 7B 2501, which governs the disposition hearing, and 7B 2512, which governs disposition orders. I'll address each in turn. Section 7B 2501 tasked the trial court with holding a hearing to select from among the juvenile's statutorily permissible dispositions a disposition that is in the best interest of the juvenile. And subsection C provides that the trial court should consider the following factors when making that selection: the seriousness of the offense, the need to hold the juvenile accountable, the importance of protecting the public safety, the juvenile's degree of culpability, and the juvenile's rehabilitative and treatment needs based on the risk and needs assessment. What Section 7B 2501 does not do is require factual findings about the disposition order, and it certainly does not command that any findings take a particular form. The Court of Appeals overlooked that key omission. Moreover, Section 7B 2501 contains several clues showing the General Assembly's desire to afford the trial court flexibility in complying with the statute. For one thing, subsection A says that a trial court may consider written reports or other evidence when weighing the 5 factors. It makes sense then that a trial court might demonstrate that it considered the factors by incorporating documents that it considered during the hearing into its finding. After all, documents incorporated by reference are treated as though the entire contents are contained within the findings. So we often think about this, because we practically have to flip back and forth between pages, as though these documents are not located in the disposition order. But the way we traditionally understand incorporation by reference is that they are in fact in the findings section of the disposition order. Similarly, another one of the 5 factors itself references a report. That's the 5th factor, which requires a trial court to consider, quote, the rehabilitative and treatment needs of the juvenile indicated by a risk and needs assessment. And finally, the General Assembly provided that the disposition order may be informal, which is at least some indication that it did not intend rigid legalism to attach to the trial court's considerations of the disposition factors. The Court of Appeals failed to consider those portions of Section 7B 2501. The Court of Appeals also misread Section 7B 2512. This is the statute that governs the content of disposition orders, and it lists several items that a trial court must state, quote, with particularity, close quote, in the order. But the disposition factors are not among those items. If the General Assembly wanted the disposition order to include specific written findings on those 5 factors, surely it would have said as much in the statute where it stated other items that a trial court must state with particularity.
How does an appellate court review an order and confirm that the trial court properly looked at the factors and the disposition factors without findings in some kind of way? I mean, if you can attach a book, is the appellate review then looking through the book whether or not the trial court did at all? Doesn't that kind of make a joke of the statute?
I don't think so, Your Honor, for 2 reasons. First, again, incorporation by reference means that all the contents are contained in the findings, and I think appellate courts are experienced at looking at an entire record, and the records are usually much larger than the records in juvenile disposition cases, and seeing whether or not the trial court considered all the things the statute says it should consider. It can look, we don't require magic words in this context and in many other contexts, and so courts can look at what the trial court did consider and infer that it considered the appropriate factors. But I also don't think that my rule will give a blank check to trial courts to ignore the considerations laid out in the statute. In fact, I believe that the rule I am setting out is what the Court of Appeals had previously been operating under in cases like INRI IWP. And in those cases, as Annie notes, the court was able to look at the disposition order, look at the sanctions imposed, look at the documents incorporated by reference, and see, yes, the trial court considered some factors, but no, it did not consider others, and appropriately vacate the order.
So you could think of those as 2 different things, though. So one is we need to know that the trial court considered all of the statutory factors in selecting the disposition. But then there's a second question in the statute, which is what are the appropriate findings? So like in this case, what findings, not incorporating something else, but what actual findings are the appropriate findings that have to be made, in your view?
Your Honor, I think there are 2 clues about what appropriate findings are here. I mean, first is the plain meaning of appropriate. We cite a dictionary definition that says it is suitable or compatible, and I think Section 7B 2501, when it says that trial courts may look at written documents to consider these factors, is trying to say it is suitable or compatible for a trial court to look at those reports to show it considered the findings.
So you're saying the appropriate finding is the boxes that are checked saying I'm incorporating these other things?
I think
Because when it says other findings, and there's that extra stuff, I mean, that to me seems like it's like a non sequitur. I think the trial court had other things that it needed to deal with involving the placement of the juvenile and put all that in the other findings. But those, I don't think, were intended to have anything to do with the actual disposition. So,
I'll take that in several parts. I slightly disagree with you about what was going on with the other findings. I certainly agree that it seemed like the trial court was addressing largely another issue, but I don't think the written other findings here are devoid of evidence that the trial court was considering the disposition factors. And I think, although my friend can correct me, I think Annie even concedes that at least one of the factors the trial court considers there. I don't think that merely checking a box saying you incorporated the documents by reference would satisfy the statute. For one thing, I think you would definitely need to also check the box that says you considered the documents. There are actually, if you look at the form on page 27, there are 2 lines. The first says you received and considered the reports. The second says that the trial court incorporated them by reference. And I do think it is important that the trial court note that it did actually receive and consider the reports. And there's Court of Appeals precedent reversing or vacating trial court orders when they don't check that box or when it's unclear what reports they received. Lastly,
it certainly would be better if there was after that another, between 2 and 3, there were like 3 becomes 4, and 3 is the court has considered all of the factors in, what is it, 2512, whatever the other statute is, having considered those factors makes the following conclusions of law below. Check that box, right?
I don't disagree that that would be better, but it is not what the statute says. And here, the trial court, or the General Assembly told us what its purposes were for the juvenile disposition statutes. It is to balance the fairness and constitutional rights for the juvenile, but also to impose swift and effective dispositions as quickly as possible. And this is the balance that they struck.
Isn't there some support for the position of the majority in the Court of Appeals by the note under other findings? Because it seems like that note directs the trial court to state findings regarding 1 through 5.
I agree that the note is an invitation for the trial court to state its findings there, but I don't think any note in the form can change the plain meaning of the statutes and what they require. The note can prompt the trial court to make its written findings more clearly, but it can't change what the law says. There is one other reason why I think appropriate findings can include documents incorporated by reference, and that's canons of statutory instruction. We typically think when the same statute uses the same words, that those words have the same meaning, and the disposition orders in abuse, neglect, and dependency proceedings also use the language that the disposition order must contain appropriate findings of fact, and the Court of Appeals has interpreted that language to permit the trial court to demonstrate that it made the appropriate considerations through documents incorporated by reference, at least so long as, like here, it also makes other written findings. I do want to turn to the structure and purpose. Although the plain text of the disposition statute resolves this appeal, in my opinion, I think the structure and purpose confirm that my view of the statute is consistent with the General Assembly's intent. So starting with structure, the disposition process has 2 phases. In the first, the trial court calculates the juvenile's disposition level, and that calculation dictates the range of legally permissible dispositions for the juvenile. The trial court has very little discretion over the juvenile's disposition level. Instead, it is sort of an equation combining the juvenile's delinquency history and her offense classification. And that level, the disposition level, goes a long way toward setting the juvenile's disposition. If a trial court concludes that the juvenile's disposition level is level 1, the juvenile knows that she cannot face probation longer than a year. But if it's level 3, the juvenile is almost certain to be committed to a youth development center, possibly until she turns 18. Because of how determinative the juvenile's disposition level is, Section 7B 2508 demands that the trial court order determine and specify the factors that combine to set the disposition level. Additionally, if a trial court wants to enter a disposition outside of the statutorily permissible range, say by declining to commit a juvenile at disposition level 3 to a youth development center, the General Assembly requires the trial court to make written findings on the record that substantiate that departure. When we move into the second step, and that's the step we're arguing about today, the step where the trial court has much more discretion to make the choice that is best for this particular juvenile, the General Assembly understandably didn't choose such mandatory rigid language. And finally, the purpose. The General Assembly provided in Section 7B 1500(4) that courts shall interpret and construe the juvenile code so as to, among other things, simultaneously protect the constitutional rights of juveniles while also proceeding with all possible speed. And as I mentioned to Justice Dietz, I believe, a little earlier, these two different phases are how the General Assembly chose to strike that difficult balance. The Court of Appeals upset that balance by imposing additional formalities on the trial court as it exercises its discretion to select an appropriate disposition. I want to briefly respond to some of Annie's counter-arguments. First, Annie makes several textual arguments, but in my reading, each one asks this court to abandon the canons of statutory construction. For example, Annie argues that the court should hold that 7B 25102A's requiring of appropriate findings of fact precludes the trial court from relying on documents incorporated by reference. But as I've previously explained, other statutes use that same language, and we should interpret that language to have the same meaning in both statutes. At the same time that Annie argues that the court should treat identical language differently, she also urges this court to treat different language identically. She expressly asks this court to ignore the differences between Section 7B 2508, which is the statute that requires written findings substantiating a decision to depart from the juvenile's permissible range, and the language in 7B 2512A. Second, Annie argues that her reading must be correct because otherwise appellate review will be ineffective. As I explained to Justice Riggs, I don't believe that that is the case. I think the Court of Appeals is familiar with the standard that I am outlining and has successfully reviewed juvenile disposition orders and sometimes vacated them using that standard. And finally, Annie argues that Court of Appeals precedent compels her reading of the statute. I disagree with how Annie traces a Court of Appeals precedent back through the years, but in any event, this court is tasked with reaching its own independent conclusion about the proper construction of the juvenile disposition statutes, and that analysis begins and ends here with this text. Because of the mootness, I'm not sure how much the court wants to talk about the particular order here. I'm happy to answer questions about it, but I won't spend more time on it myself, other than to say, if my briefs failed to convince you that this particular order satisfied the statute, even if you look at the documents incorporated by reference, you should nevertheless reverse the Court of Appeals legal holding here, so that in the future, other trial court orders that do consider all the factors through documents incorporated by reference, and again, I'm not conceding that this one does not, have the opportunity to do so. If there are no further questions, I will reserve the remainder of my time for rebuttal. Thank you.
Thank you, counsel. We'll hear from the appellee.
May it please the court, my name is Katie Dickinson Schultz. I'm an assistant appellate public defender, and I represent Annie on appeal. So prior to starting my argument, I want to point out a minor mistake I made in the record, hopefully to clear up any confusion I might have caused. In the record on appeal, I labeled the predisposition report the pre-tally worksheet. That was just the predisposition report. The predisposition report is made up of a whole bunch of different individual reports. I just mislabeled it. I also put it before the disposition order. It should go after, because anytime the district court incorporates documents, it has to attach them to the order. And these were the documents that were attached to the order. I'm going to just say a quick sentence about mootness, because I feel like our motions did a pretty good job. So I disagree that this is a matter of public interest. We have settled case law in the Court of Appeals on this issue. It really hasn't changed since 2011. This is a consistent interpretation of the statutes, and there really just is nothing new here in this case. While I am happy to talk about disposition orders and appropriate findings and all this sort of stuff all day, I really don't think that this is a really large matter of public interest.
So it's interesting because you say that, of course, your friend takes the opposite position. That
Yeah, sure.
This case is sort of an anomaly and that everything was settled until this happened.
Yeah.
But I suppose from your client's perspective, if we were to say it's moot, but having, come up and done the full briefing, said this particular decision will stand without precedential value,
Right.
that doesn't have any impact on your client.
No.
So I guess that's one option if it would seem to satisfy both of you.
Right.
Whether it's settled now or it was settled then, the Court of Appeals can work that out in future cases.
Right, right. The disposition, I guess, would still stand in that case, if you're saying
Well, the Court of Appeals decision would stand.
the Court of Appeals would stand, so the disposition would go away.
Right.
Right. So she would just be adjudicated, but no disposition.
It just wouldn't be a published opinion, essentially, from the Court
That's
of
true.
Appeals.
That's true, which I'm fine with that, if this court dismisses it as moot. So before addressing why the state and dissent are wrong in both their interpretation of the statutes and why they're wrong in their argument that they can somehow tell that the trial court properly considered these 5 factors, I think there are 2 important things to remember. First of all, we're talking about juveniles. The General Assembly has created very specific statutes on how they can be punished, and there's good reason for this. The whole purpose of juvenile dispositions is rehabilitation, unlike adult offenders when you're looking at punishment and addressing, somebody's injury. Juveniles don't get jury trials. The hearings are a lot less formal than, say, an adult case. That's why any extra protections or rights that are built into the statute should be strenuously enforced. I think it's also, I just briefly want to point out what was going on with Annie at the time of this case, and also point out what this disposition order actually, required her to do. At the time of disposition, Annie was homeless. Her mother had kicked her out of the home and wouldn't let her back home, and so she had nowhere to go. She was 16 at the time of adjudication and disposition. Also, this disposition order wasn't just 12 months of probation, the most the trial court could have ordered under the statute. Some of these conditions of probation were incredibly punitive. Annie couldn't hang out with anybody unless she got prior approval from the court counselor. She couldn't go places without prior approval. And in fact, she couldn't have any contact with her biological mom and biological sister. And frankly, Annie was put in a position where she could have been brought back to the court on a motion for review simply by having a conversation with her biological sister. Moving into the law, there really isn't a whole lot to say about the statutes here. 7B2512 requires that an order be in writing and contain appropriate findings, not just findings, but appropriate findings. If you look at 7B2501C, in every disposition order, regardless of whether it's within, whether or not she got 2 months of supervised probation or 12, the trial court must consider 5 things when deciding what disposition to pick. Now, the term appropriate is not defined in the statutes, but we see this term a lot in cases like Annie's with adjudication orders and dispositions, but we also see it, as my colleague mentioned, in abuse, neglect, and dependency. And when the Court of Appeals has looked at, well, what does appropriate mean? They have looked at whether the findings address all the things that the court needs to address, or consider, not address, but consider when making an order. For example, in RECM, which is a case cited by the state in the reply brief, one of the orders was ceasing reunification. And at the time, I believe it's 7B 507, I don't think that's, I think either that statute's maybe moved somewhere else or changed. I am not an expert in abuse, neglect, and dependency. But the court was required to make appropriate findings. And the court looked at whether there were appropriate findings in this order, and I think there were 17 findings. And the findings didn't just address the evidence, they also addressed all the statutory factors that a court has to think about when deciding whether to stop trying to reunite a child with their biological parent. And the court found that it was sufficient. In other cases
So what's your position if there was an order the court had entered in a case like this,
Okay.
and the findings said, I have considered all of the statutory factors, cite the statute, and then says, of particular note are some, and then it discusses a bunch of specific findings about one of the factors, and then says, therefore, I conclude level 1 disposition.
Right.
Do you think that would be enough, the express finding that I've considered these, but I'm really going to just talk about this one that's important? Or are you sort of on you've got to list them out, bullet point every single finding that you have relevant on every one of the factors? Where are you at on that?
I am, well, certainly that order would be a lot better than the order in this case. But I will say that under my interpretation of the statutes, that just checking a box saying I considered all these factors, but I only think this one's important and it's the only one I'm going to talk about, I don't think that would be enough. I think the trial court really does have to look at all these factors. Now, how the trial court balances these factors, how it weighs and says, for example, there could be a finding about while Annie wasn't, didn't have a high level of culpability in this case, I think her needs outweigh that. That would be a great finding. I'm not saying that there's some magical formula that, culpability equals 2 points and this, and you add it all up and figure it out. But I do think there has to be a little bit more work, given that the whole purpose of juvenile dispositions is to weigh the needs of the state, which include things like safety, but also holding the juvenile accountable, thinking about juveniles themselves who are more susceptible to somebody suggesting they go do something, right? I think because of that, because that is the only thing that dispositions are supposed to do, that there would have to be findings on all the factors. They don't have to be voluminous, right? The trial court could say, here it appears with regard to the use of the car, Annie was the only one who planned it and she took the car. She was the only one who did that. I think you don't have to go any further.
But couldn't the General Assembly have, if the intent was that the trial court shall make findings of fact as to each of these factors, certainly it could have said that more clearly.
Yes, sometimes the General Assembly is a little clunky, some of their statutes. I agree, but I don't see any problem necessarily with how this is written. Could it have been crafted better? Maybe. But the way it's been interpreted and the way it reads, I don't think that it would lend itself to the state's interpretation.
It seems that essentially you're asking us to say, well, if there aren't express findings, the conclusion is the trial court didn't consider these factors. Why shouldn't the presumption be the trial court did consider them, because we presume the trial court knows the law?
Right, and there is this presumption that trial courts do the right thing. I think the problem is I've never seen that in a case where findings are required, the trial court doesn't do them, and somehow the appellate courts will swoop in and say, well, if the trial court had made these findings, then this would what it would be. I just don't think the appellate courts are in a position to go back in time and, figure out what was in a trial judge's head, because if the trial judge picked a disposition not considering these factors, then that was unlawful. So if the statute could be rewritten, maybe it would be. But what's funny is that this is how these statutes have been interpreted since at least 2011 in the Court of Appeals, since In re VM and In re A.G.J. and all this. The General Assembly hasn't changed the statutes. even though there's been 2 major overhauls of the juvenile code. So my rebuttal is that if the General Assembly really didn't like how this was being interpreted, then they would have changed the statutes.
In State versus Van, that's a jury instruction case. We basically said the presumption of regularity attaches, and in the absence of some affirmative evidence from the defendant, we're going to presume that trial courts did what they were supposed to under the law.
Right.
Is there any affirmative evidence that the trial court didn't consider these factors?
I would say, given that Annie got the most probation allowed under the law with all these conditions, even though she committed 2 very low-level, non-serious misdemeanors, it does not appear that she was culpable, at least in the school fight. Some of the needs that the trial court, some of the conditions of probation, that she couldn't wear gang colors, I have no idea where that came from. There were also things about getting drug and alcohol counseling. I'm not really quite sure, even looking at the incorporated documents, where that came from. So I'd say if you look at what the trial court ordered here, because I can't trace that back to where it came from, then I do not think we can say the trial court did its job.
Are those conditions of juvenile probation consistent with a level 1 disposition?
They can be, yes. But I think if you look at that every disposition, and including the probation conditions, have to be tailored to the juvenile herself, I don't think that this order looks very tailored to Annie's situation at the time. I agree with the state that findings don't have to use magic words. I don't even think they have to track the language of the statute. But they need to indicate some consideration by the district court of these factors. I mean, the district court could write one finding that maybe addressed a couple factors all at once. Again, I'm not looking for some formula here. I think you just have to look at, why would the General Assembly say, you know, a trial court has to make not just findings, but appropriate findings, and that the trial court has to consider these 5 things, but not require the findings to somehow indicate consideration of these things. And I don't remember who asked the question, but the whole purpose of findings of fact is to show what the trial judge was thinking. How was the trial judge in this case looking not only at the evidence of these offenses and everybody's recommendation, but looking at those things through the lens of these 5 factors, and tailoring the disposition to Annie herself. There's simply nothing more appropriate or pertinent to a disposition order than these 5 things the General Assembly has said you must consider. Adjudicating, I just don't see this as a huge burden on the trial courts. Excuse me, on the district courts, I should be clearer. Adjudicating juveniles and sentencing them requires a judge do more than reading a sentencing chart like you would with an adult offender. And district court judges are used to making findings. If you think about all the things they do, whether it's family law or termination of parental rights, I mean, every single order requires some sort of findings. I think the alternative to having findings that somehow indicate consideration, the alternative, like the state in the dissent would put forward, would require one of 2 things. Either every single adjudication order would have to be affirmed if the evidence, if there was evidence anywhere in the record that could support the sentence, even if that's in these voluminous predisposition reports, even if we have no idea whether the trial court looked at that or factored that into his reasoning of why he picked certain dispositions, or the appellate courts would have to be fact finders. Because if the district court's required to make appropriate findings but doesn't, then somebody's going to have to if you want to review the sufficiency of the order. And I can say, while there's certainly no hard and fast rules when you're looking at what findings have to look like or sound like, or even, you know, where they are in the order, I don't care where they are in the order. They just have to be somewhere. I would prefer they go in the section labeled, here's a place to write some findings and here's some things to consider. But if you look at the findings in this case, they are real insufficient. The findings only address things that happened at the hearing, like the fact that Annie was late. It also addresses Annie's living situation, But these findings aren't appropriate because they don't speak at all to culpability, seriousness or lack thereof of these offenses, her needs, anything like that. With regard to seriousness of the offense, we don't know if the trial court considered these very low-level misdemeanors serious, or if it didn't, why impose so much probation? In other cases where the appellate courts have looked at this factor, one of the things the courts will look at is whether a juvenile intentionally committed a crime or was willful, or the nature of the crime itself. And what's interesting in Annie's case, if you look at the facts of these offenses, the disposition order makes even less sense. So looking at the factual basis that the state presented at adjudication, with regard to the simple affray, the facts were that Annie was at school, it was lunchtime, another juvenile approached her very aggressively, something happened, it got physical, but there was no indication this was a violent fight or that anybody was seriously injured. And in fact, both juveniles apologized to each other after the fight. With regard to the taking her mom's car without permission, we don't know anything about that, other than she, quote, took the car. We don't know if she was driving the car. We don't know, did she put other people in the car and put them at risk necessarily? We don't know the facts, and we don't know if the trial court considered this stuff when thinking about her, the seriousness of these misdemeanors.
Let me be sure I understand. You don't disagree that the trial court appropriately considered the predisposition report that it indicated it had considered?
Oh, no.
How did the ultimate disposition disagree or differ at all from that recommended in the predisposition report that's found? I'm looking at the appellant's brief and the appendix, page 23, and what's recommended there.
I'm sorry, on page 23 of the brief?
I'm sorry, it's, let's see, it's the appendix, page 24. It's page 23 in the record, I guess. Yeah, page 23 in the record.
Oh, 23 of the record.
I mean, you were questioning where did all this come from that ended up in the disposition. And
Right.
Seems to me it came almost verbatim out of that.
The page 23 of the record, Chief Justice?
Yep.
Oh, I do. Are you talking about the gang, the gang thing that I said I didn't know where? Okay, well, maybe it did come from that, but we don't know, you know, when looking at later parts of the report in a section that talks about gang information, it does not indicate that she was a part of any gang or that she stole the car with gang members or anything like that. So I apologize, I misspoke.
It also addresses the illegal substances, alcohol usage.
Yes. And her mother did speak about this. The problem is not, my issue is not whether some of this stuff could be justified, is that I don't know how the trial court justified it.
Well, by checking the box saying it had considered this report, isn't that telling us where the trial court would have gotten it?
Right. I think if you look at this case with the incorporation of documents, which my position is not that you can't incorporate documents and they can't be part of the consideration. My problem is how a trial court interprets these documents is really important, because sometimes these reports contain tons of information that would support any number of outcomes, sometimes different than what the trial court ultimately picks. A reviewing judge is going to find some of this information credible, more helpful than others. And we just need to know what it is that necessarily the trial court was looking at and thinking about when deciding what type of disposition to give her, especially the most disposition he could give her under the statutes. You know, and I think this is really important if you look at this case, because the predisposition reports that were incorporated and attached, they're not even complete. These are just sort of snippets of, some of these reports. So, for example, I don't know, one of the information was that she has a social need of 45. I don't know what that means. I don't know what the context of that is. And so maybe the trial court did find that important. I don't know. But without even just the full records, I don't know how to interpret any of this information. And while the trial court is certainly allowed to incorporate it, I think there has to be some more indication of where on the record the trial court's looking at when deciding what's important. I don't think you can supplant the need for findings simply because you incorporate these voluminous records. Another thing we don't know from this record is, from the findings, we don't know how the trial court weighed her culpability. This factor isn't just whether the juvenile is culpable, that's already been determined, but it's a degree of culpability, because we know juveniles sometimes agree to do things they wouldn't normally others if somebody else suggests they do it. But had the trial court look at the circumstances of, say, the fight, it doesn't appear that Annie was the aggressor, so that would suggest to me a very low-level culpability, but we have no idea. There was nothing in these findings speaking to the culpability.
Again, the same report says that she was involved in bullying behavior, and that the other individual said that she had been bullying her.
Right. And again, if she was bullying other people, I don't know if that really speaks to what happened here. I think that's a great place for the trial court to say, well, I see there's this bullying allegation. Did that play any role here? But it's not clear how some of the snippets of information in these voluminous records played a role in the trial court's consideration of her culpability. I think interpreting the statutes in such a way that the findings can't just be, we can't just skip over the findings. They need to show some sort of proper consideration. I think it makes sense for several reasons. First, if the trial court didn't have to make these findings, every disposition order would be final. If under the state's logic, if you check a box that you're incorporating documents and you make some findings, even though the findings don't really address these 5 things, the trial court would have carte blanche authority to impose any and all dispositional alternatives, and the appellate courts would have no way of knowing whether the trial court did its job properly. Certainly, the General Assembly didn't intend for these disposition orders to not be subject to meaningful appellate review. Second, it's not just the majority or Annie who thinks the trial court has to make these findings. The Court of Appeals has held this since 2011, that the findings have to indicate some consideration of these factors. And as I mentioned before, the General Assembly has not changed these statutes, even though there's been significant overhaul. And I think another important entity to think about here is that AOC has put in the pre-printed disposition reports, here's a section for findings, here's where you need to address, and even list out what those 2501C factors are. So I don't think AOC is in the business of necessarily making it harder on judges' life, and I think the fact that this is right here in the pre-printed order should have made the trial court think, okay, here's where I need to address some stuff.
Yeah, but in fairness to our colleagues in the trial division, the AOC form says other findings, which isn't really consistent with the idea that these are findings you have to make. When you see something like that on a form, you may think, okay, by reference, incorporating by reference, I might have done enough, and then this is optional, essentially.
Right.
But I get your point, and I think Justice Earls made this observation that, as you say, when it says note, everything that's listing there is your argument of what the court should have made findings about here.
Right. It should be labeled the findings, not other findings. I agree. But we have seen plenty of disposition orders come through our office that do have sufficient findings, right? So this is not just as soon as we get a disposition order, like we start, cranking out the briefs that just say, oh, we didn't consider the factors. We've seen plenty of orders that do just that. And another important consideration that if the trial court didn't have to make these findings, it would always be ceding or delegating all its authority, decision-making authority, to a trial court counselor, or what it says on maybe, one snippet of a report. The trial judge in juvenile dispositions is a very important part of the process. He or she is going to get tons of information and digest it and try to figure out, while considering these 5 things, what to do for this juvenile that's standing before them. And while the trial court's totally welcome to adopt recommendations, there has to be some sort of logical reasoning that's involved with that. And I think that this kind of goes back to what are appropriate findings. It's more than just a recitation of, here's what happened on July 25th. Annie got in a fight, right? There's this idea that it's almost more like an ultimate finding of fact that indicates some reasoning and consideration while looking at the evidence. Just briefly, the state talks a lot about its concern that because the 2512 requirement for appropriate findings is separate from the factors in 2501, that somehow this means the trial court's findings don't have to address it. But the state doesn't explain why the General Assembly would say, no, you have to make findings and you have to make appropriate findings, but those findings don't have to address the 5 things you have to consider in every single disposition. Nor does the state explain how there could be meaningful appellate review if boxes are checked and there are some findings, but maybe the findings don't address all 5 things. We'd have to just assume the trial court did the right thing. Nor does it explain how a district court judge could demonstrate its consideration of these factors other than the findings themselves, because that's what findings are exactly designed to do. The state also spends time gleaning findings from other parts of the disposition order, but the state's argument doesn't hold up. With regard to seriousness, the state contends that because the trial court ranked the seriousness of the 2 offenses she admitted to doing, that somehow that shows it considered. So all this shows is that the trial court knew the classification of these offenses, not necessarily how serious one was or the other. With regard to accountability, the state argued that because the trial court held her accountable, then that means that accountability was considered. But the state's position is unfalsifiable. I mean, you couldn't prove it was untrue because imposition of every disposition would mean that accountability was considered. So I don't know why the trial or the General Assembly would say you must consider this, but we can presume you considered it because you entered a disposition order. The state also suggests that the trial court considered culpability because Annie admitted the allegations, which she absolutely did, and the fact that the trial court said she had no contact with her adoptive mother. I mean, culpability can only be really assessed by looking at the circumstances of the offense, not just whether a person has admitted to doing it. And I'm not quite sure what her relationship with the mother who had kicked her out of the house had anything to do with her culpability in these offenses. I think unless there are further questions, we would just ask this court to either dismiss the case as moot and not a public interest, or affirm the decision of the Court of Appeals. Thank you.
Thank you, counsel. Rebuttal.
Thank you, Your Honor. I just want to make 4 points very quickly on rebuttal. First, regarding mootness, I continue to believe that this case satisfies the public interest exception, but if you disagree with me and you dismiss this case as moot, I would also ask that you vacate the Court of Appeals decision. Second, counsel for Annie said that the state was advocating for a view where a trial court order could be affirmed even if the evidence that it considered the factors was everywhere in the record. That is not correct. We do think it has to be in the disposition order. We just think documents incorporated by reference are in the disposition order. She said that the state's position would allow this, even if it wasn't clear. If the trial court considered the report, again, I disagree. It is important that the trial court consider the report. I think checking a box, especially with the presumption of regularity that is afforded to trial courts, suggests the trial court did consider the report, but other Court of Appeals decisions have also looked at things like the transcript to assure themselves that the trial court really did consider the reports incorporated by reference. Turning to the burden of this, I recognize that in individual cases, writing out additional findings might not seem like the greatest burden to the trial court. And I have two responses to that. First is, in the aggregate, it will have a significant burden. Our district courts hear many juvenile cases a year, and they are also busy with many other things. And the General Assembly has emphasized the need for swift dispositions imposed as quickly as possible. And that gets to my second point, which is anytime a statute is interpreted in a way contrary to its plain meaning, that is a burden and harm to the state. And then finally, on Annie's point that this is the interpretation that the Court of Appeals has had going back to 2011, I disagree, and I think Annie is over-reading one particular case in the Court of Appeals precedent. It's called In Re V M. In that case, there were no written other findings, and that is why the Court of Appeals vacated that trial court order. Subsequent decisions by the Court of Appeals have cautioned advocates not to overread VM in the same way that Annie is. They did so in a case called In Re GC, and that's at 230 NC Appellate 511, Penn Site 520. I'm merely modestly asking this court to return the precedent in this area to what it was for as long as the Court of Appeals has been doing these cases by my reading. That is the standard employed in cases like In Re IWP, where the trial court the Court of Appeals looked at the entire disposition order and concluded the trial court considered some factors but not others and vacated. Or In Re JAD, where it did the same thing. Or In Re RVG, an unpublished case where it looked at the other findings in addition to the documents incorporated by reference and found there, combined, it had considered all the factors. So to close, I would ask this court to reverse the judgment of the Court of Appeals. Thank you.
Thank you, counsel. Thank you both. Mr. Clerk.
Rise.